Hi, I'm Carrie Norris, Senior Vice President of Legal Services and Chief Legal Officer at Legal Shield. I want to take just a minute to talk with you about the importance of making your will. August is National Make a Will Month, and there's no better time than right now to make sure you and everyone you know completes this important document. A will is the single most precious gift you can leave for your family. You know, too many people leave this life expecting their family members to take care of the distribution of their property. However, if a person dies without a will, he or she is considered to have died intestate. That means a property will be distributed according to the state law. Typically, if a person dies without a will and without any heirs, the property is then turned over to the state. A last will and testament is not just an opportunity to ensure who inherits a person's property. It's also an opportunity to designate a guardian for minor children, make provisions for family beloved pets, donate to favorable charities, and much more. At Legal Shield, we recognize the importance of making a will. Last year, over 32,000 Legal Shield members completed their will. Our Legal Shield family provides a standard will with annual review and updates included at no additional cost. And completing a will is easier than ever before with the Legal Shield mobile app. Legal Shield members can complete their will questionnaire and upload it directly to their provider law firm using our exclusive mobile app.
Hi, my name is John Stevenson. I'm an attorney with Madelman, Weinroth, and Miller. One of your main concerns should be when deciding whether or not you're going to draft a will is what happens to your children in the event that you pass without a will. There are two main considerations that you should be thinking about. First being the custody of your child, and second being how your assets are going to pass. With respect to custody, if you pass and you have a surviving spouse or the biological parent of the child is still alive, that individual will more likely than not take custody of the child if they're willing to come forward. If that individual does not exist, then a court will appoint a guardian for your child. More likely than not, the appointment of the guardian will be someone who is a biological relative to the child. However, the judge must take into consideration the best interests of the child, and this may not always be the case if a relative is deemed to be unfit by the court. Also, another consideration is the child's age at the time that you pass. If the child is of an age that they are reaching adulthood or a young adult, the court may also take into consideration their preference. With respect to your assets, every state has rules of intestacy, and basically these rules are put in place by the state that if you pass without a will, it's okay, the state has made one for you. In most instances, while every state's rules vary a little bit, spouses will primarily inherit first, followed by biological children. If there is no surviving spouse, biological children will take in equal shares. It's important to take into consideration the age of the children at your passing. If these children are minors at the time you pass, a conservator will have to be appointed on behalf of the child. The conservator's job is to manage the finances or inheritance that the child will be entitled to until the child reaches the age of majority, which differs from state to state. While this is a difficult subject to approach or think about, it is very important that you have a plan in place for the benefit of your children.
Hi, my name is Laura Berlin. I'm one of your attorneys at the Missouri Legal Shield provider law firm, Dubale Judge. One of my favorite aspects of the Legal Shield plan is your estate planning benefit. At no extra charge to you, you can have your will drafted by an attorney in your state. It's really quite easy. To get this done, you go to your app on your cell phone and answer a few questions. In the alternative, you can call your provider law firm and ask them to send you a paper copy of a questionnaire. Once you've completed the questionnaire and returned it to your law firm, one of your attorneys will call you to go over your answers. Based on that, they'll draft your will for you. You should have your will done within 2 weeks. See, it really is quite easy. I encourage all of you to do this. Thank you.
A will is the single most precious gift you can leave your loved ones. Without a will, your assets, including your property, may be distributed according to the laws of your state of residency. A will also allows you to designate legal caretakers for dependent children and pets. Surprisingly, nearly half of full-time working Americans do not have their will prepared. Legal Shield believes that everyone has the right to a will. We provide easy and affordable access to reputable attorneys who can prepare your will. And with the Legal Shield mobile app, you can begin the process from anywhere. Using the mobile app, simply select the will questionnaire and enter your personal information, along with asset information such as motor vehicles, properties, and investment accounts. You can also enter any end-of-life requests for special arrangements, such as who will care for your pet. Once you've finished adding your information, simply tap Submit, and your provider law firm will prepare your will for your review within 5 business days. Legal Shield makes it simple. Start the process today and have peace of mind tomorrow.
Hello, my name is Bill Thrush. I'm the managing principal of Friedman, Fromme & Thrush, a Legal Shield provider law firm. So in our law firm, we get a common question: when should I update my will? Should I only do it when my circumstances change? The simple answer to that is yes. When your circumstances change, you should update your will. However, you should have a more broad definition of what a change means. Everyone can understand a change if there's a birth of a child, a death of a family member, or someone gets married or divorced. Those are readily apparent. Those are easy to identify. But you should also keep that more broad definition of a life change in mind. For example, if you or your spouse loses your job or changes your job, that might trigger circumstances that will warrant a change in your will. If your financial status changes, for example, in a positive or a negative direction, take a look at your will. If you relocate your residence either to a different county or to a different state, you should look at your will. If your health status changes, you should look at your estate plan and see what the impact might be. If there's a change of law in your state, and not just with respect to probate law, but with respect to any law that might impact your finances, you should see how that change impacts your estate plan. As you age and as your heirs age, you may want to make changes to your estate plan. For example, if you have minor children in there, and they have reached the age of majority, maybe that trust you set up is no longer appropriate. And finally, if you have assets that you want to leave behind to your family members and those assets are gone, or you obtain new assets that you want to make sure get left behind the way you want, you should use that as an opportunity to visit your estate plan. Now, keep in mind that every person's situation is unique and every circumstance is individualized. Keep also in mind that every state's laws are different. So you should call your provider law firm and check with them about your specific situation. And remember, no matter what, under any circumstance, you should have your will looked at every 3 to 5 years. When in doubt, check it out.